Otto, who is from Bowler Engineering, who was, through technical assistance awarded through the Mass Housing Partnership, has been running the numbers on all of these locations. And for somebody that loves spreadsheets, this was a spreadsheet that was too difficult for me. So I had somebody else come in on this. And then also we have Brian Winter, our town council from Meade, Tellerman, and Costa, who will also be able to present. So I'm going to share my screen. Hopefully this will work. It worked last night, so fingers crossed. I share the right one, and I don't share the presenter view. Okay, you guys seeing the first slide?
Yep.
Multifamily. Okay, so multifamily zoning requirement for Wrentham. The Section 3A program, or otherwise known as the MBTA communities. Let's see. Okay, so just a little brief overview, introduction. We're going to go over what's an MBTA community, why was Wrentham designated, what are the requirements for compliance, where are the proposed locations, a little bit of what it's going to look like, what happens if we don't comply, just some important clarifications, next steps, and I have some resources and links in there too. And once this is over, I will have this up on the website PDF'd. And so all of the links you'll be able to click on and review at your leisure. Okay, so as a couple years ago, an economic bond bill was passed by Governor Baker, which designated 177 communities as MBTA communities. Wrentham is required to zone 50 acres near an existing downtown or village center that allows for multifamily housing as of right, without age restriction, suitable for families at a gross density of 15 units per acre and a unit capacity of 750 units. Important understanding, this is not a production mandate. It is just to zone 50 acres with those items above. It's not related to Chapter 40B. So while the draft bylaw does have an affordability component in it, it is not the same as Chapter 40B, where Chapter 40B will waive all of the underlying zoning. So over the past year, the town has been working with not only a couple members from the planning board, but also the Board of Selectmen, and then off and on with some consultants to identify areas that meet the state's compliance model. The deadline to adopt this is December 31st of 2024. If we don't comply, we'll be ineligible for grants and loss of points on other competitive grant programs, along with many other things. The Attorney General has also stated that failure to comply will result in civil enforcement. So what exactly is an MBTA community? Well, again, as part of this law, it designated these 51 cities, 14 cities, all defined within the MBTA law. And we are designated as an other community served in that definition. As part of that also, 177 municipalities were given distinct classifications depending on what type of MBTA service they had. Wrentham is an adjacent community because we don't have any stations within our borders or within a half mile of our borders. But we are adjacent to 3 communities that do have a station, most recently Foxborough and their permanent station. This is just a map showing all the 177 communities with Wrentham circled. I don't know how Avon's got out of that. This is just a definition of all the different classifications. And again, we're an adjacent community. And here are some of our neighbors, North Attleboro, Medfield, Millis, Medway, and Bellingham were also adjacent communities. So why were we designated? So as part of this economic bond bill that Governor Baker signed in January 2021, this bill included a range of housing provisions. It also included changes to the Zoning Act, which is 40A section, and the Section 3A is different uses and definitions. And it created these MBTA communities, and it encouraged them to create zoning where multifamily housing is permitted as of right. And again, it meets other requirements that I said before. And if you love to read text of laws like I do, This is exactly what it says. And again, it's a MBTA community has to have a zoning ordinance or bylaw, provides one district of reasonable size where multifamily housing is permitted as of right, provided that there is no age restriction, and it has to be suitable for families. And, you know, in an area of reasonable location. And so again, this is the 15 units per acre. And this doesn't usurp the Wetlands Act. It doesn't usurp Title V. So they still have to meet those sections of those applicable laws. And again, because we're an adjacent community, we have a little bit different of a location guidelines on this, which I'll get to in a future slide. And again, that says if we don't comply, these are the named funds that we won't be eligible for. And I also just put some examples of what we've used this money for in the past. And again, the Attorney General has issued a statement that clarifies communities who do not comply will be subject to civil enforcement action. We can talk about that later. And just some definitions. Again, what does reasonable size mean? In this case, it's 50 contiguous acres. That's now been, at least one of the overlays has to be 25 acres, and then the rest can be 5. But you have to have at least one district that's 25 acres contiguous, and then the other, you can have other ones of 5, so long as all of those districts have a average density of 15 units per acre. And so multifamily housing, a building with 3 or more dwelling units, as of right, a development that may proceed without, you know, it has to meet the bylaw that's in place. So it's not just, here's my plan, this is what I'm doing. They do still have to meet and prove that they're meeting this bylaw. But the board, there is no discretionary permit, like a special permit or a variance. In this case, we've written the bylaw to be a site plan approval. So that way the planning board still has some eyes on this as too. All right, and so what are the requirements for compliance? So we need to have zoning must allow for multifamily housing as of right. Our proposed zoning bylaw has that, except, you know, with a site plan review. Again, so the planning board has some eyes on it. And the applicant has to prove, again, not just a piece of paper that they're saying, here, I meet it, I can build it. They have to still prove that they meet the bylaw. Zone must be of reasonable size. We've done this in 2 different ways. Angela will go into that a little bit later, but both instances, options do meet that reasonable size of 50 acres. Minimum gross density of 15 units per acre and a unit capacity of 750. Again, in both instances that Angela will go into, of the 2 locations, it works to meet this. There is no age restriction. In ours, we don't have any maximum bedroom size or counts or, you know, age restriction either. And both of the locations are near the downtown and Wampum Village Business District. So located near. And so again, I said this before, Wrentham is classified as an adjacent community. So this is defined as a community, MBTA community with no transit station within its borders or within a half mile of its border. And so the guidelines go on to say that if an MBTA community has no land area within 0.5 miles of a transit station, the multifamily district should be located in an area with reasonable access to transit station based on existing street patterns, pedestrian connections, bicycle lanes, and an area that otherwise is consistent with the Commonwealth sustainable development practices. For example, near an existing downtown or village center. We don't have a regional transit bus stop or line, or in a location with underutilized facilities. So in this instance, we chose to sort of focus on the near an existing downtown or village center areas. And so this is just, you know, what we considered when we were looking at these areas. So I think we started with these are the ones that I had asked Angela to run the numbers on, so to speak. There's some others that we'll go into that just didn't, off the top, didn't meet the requirements for an adjacent community or meet the Commonwealth's sustainable development principles. And so first we have the downtown location. And again, this very much this matches the adjacent communities requirement in an existing downtown. The village zone language that's already existing, the underlying zoning, already pretty much matches what the state is requiring for the MBTA communities. You know, we did this one as a mandatory mixed use because so that way we are in keeping with the 2018 vision of the rezoning for this. So requiring at least a percentage of it to be mixed use, which again is in line with what you guys sort of approved back in 2018 with this rezoning. And so that just brings the unit count down a little bit, but we make up for that in elsewhere, which again, Angela will go into once I get through these. And location number 2 is the Wampum 495 area of 1A. And so again, this is near an existing, you know, village center or small business center of Wampum area. And this one would have a 15 units per acre, 25% lot coverage. And again, Angela will go into the different options and how the numbers ironed out as well. So here are some of the ruled out locations. So development center, this would have been, you know, a really great place to go. But the guidelines say that publicly owned land is defined as excluded area under the guidelines. And they go on to further say that it also needs prior approval from the state agency who owns the property and be included in the housing production plan. Wrentham has never had a housing production plan. They had an affordable housing plan in 2005. They only last about 5 years. So that expired in 2010. So that is out. Eagle Brook. This one, we couldn't make, this was a 40B project. We couldn't make it work with the numbers. Required a lot of changes to the zoning that didn't meet the compliance model. So this one was ruled out as well. Route 1 area, it's commercially zoned, and in Wrentham is a split tax rate community. So residential tax rate is lower than commercial tax rate. So putting residential in a commercial isn't an ideal situation. And there's not really much for existing street patterns or there's no sidewalk access. I don't see anybody playing on the solar farm on the capped landfill over in Plainville. So that one was ruled out. Also the Beach Street and Taunton Street, we know they're doing something else anyway. And also there's a lot of wetland areas, as you can see here. And so the numbers wouldn't have made out here. So that one was ruled out. Green Street, this is the same as Route 1. It's commercially zoned area. There's a lot of existing, industrial uses on this road and warehouses as well. And as somebody who walks in this area, it's there's opportunities for pedestrian walking unless you're going on the Greenway, the future Metacomet Greenway Rail Trail. So that one was ruled out. So Chestnut Street also, this was one that came in. This one had, similar to one of the previous slides, it's just got some wetlands on here. There's some steep slopes. There's a lot of easements through this property. So the numbers just wouldn't have worked. And this is not really an area that you would see that type of a use either. So that one was ruled out. So with that, I'm going to give you a break from hearing my voice, and I'm going to pass it over to Angela Botto of Bowler Engineering. Take it away. If she's unmuted. No, she's not. Okay, hold on. Ask to unmute. There we go.
Awesome. Thanks, Rachel.
You're welcome.
So what we took was based on all of that information that Rachel just shared on those previous slides. We took that and we analyzed that through the state developed compliance model. And I'll get a bit more into the details on that on the next slide. But we came to the conclusion that the Wampum 495 area and the downtown area that we shared were the two ideal areas for a state compliant plan. So our option one, we are showing in red one overlay district that is in the Wampum 495 area, and that would be the MBTA Communities Overlay District. Oh. Along with that, we would then propose a mandatory mixed use overlay district. And while the mandatory mixed use does not count towards the MBTA communities, it does allow for up to a 25% reduction in the required unit count. And we'll see those numbers on one of these slides after this. So we have that one option there. And then we do have a second option, and that is a larger overlay district in the Wampum 495 area with no mandatory mixed use. And that we're calling our traditional approach. So what did we analyze? So we utilized the state developed compliance model to check all of the proposed locations that Rachel just ran down. And so what we did was we took all the data that the state provided on each of the parcels that we looked at. We put that into a GIS mapping program to review each parcel, the size of the parcel, if there was any excluded land on the parcel. And then through the compliance model, it spits out these results, which are shown at the bottom of the slide. So we were able to compare different districts to see how we could meet compliance. So the three main things that we looked at were area, unit capacity, and then density. So Wrentham's required area was 50 acres, 750 units, and then for all of the MBTA communities, it's a required density of 15. So we have proposed a density of 15 with that overlay district. So getting a bit more into our option one. So in red, we have the MBTA Communities Overlay District. So that is 50.1 acres, and it's giving us a total unit capacity of 726. And you may be wondering why that says 17.2 units per acre, but that takes into consideration the size of all of the lots and any excluded land on that lot. So while we are proposing within the zoning 15 units per acre, that net that the model comes out with is 17.2. So we're meeting the required just by over 0.1 acres. We are over in the unit capacity, but in order to keep compliance with the area, we had to keep all of that there, and then proposing the 15 units per acre. So for this version, we have 13 total parcels within that MBTA communities overlay. And then we have also proposed to rezone this downtown area to the mandatory mixed use overlay. So this, as I mentioned, is separate than the MBTA zoning. This is the existing village zone, and we are proposing a density of 8 units per acre. This would have a required ground floor commercial use, and the requirement from the state is that it cannot be more than 33% of the total building area. So what that did was we had a required unit capacity of 750, but by proposing a mandatory mixed use, we were able to lower that to the 562. So we were able to take out a few parcels that you'll see in the second option. And this is our traditional approach. So this had 18 total parcels, which was 54.7 total acres. We got 750 total units, so we're complying there. And then we proposed a density of 15 units per acre. So again, taking into consideration any excluded land and the size of the parcels, that net units per acre did come out to 16.1. So for this, it was the unit capacity that was really driving the size of this district. And I did want to note that all of the districts that I mentioned are overlay districts, and that all the dimensional requirements for the underlying zoning will still hold true with these proposed overlay districts. I will turn this back to Rachel. I'm sure there'll be some questions after the presentation. Be happy to answer.
Thank you, Angela. And so you may be wondering, a lot of us, I can't envision stuff. I need to see a picture. So this is just some examples of projects that are at that 15 units per acre. And so, and again, I have links to the actual project on the pictures. So when it gets to PDF, you guys can take a fly through of these. So this is the Avalon in Sudbury. It's 15 units per acre. It's a total of 250 units. It's on 17 acres. This was done through a 40B, so not the same, but that's, it was built in 2019. And maybe some of you know this area, but it was part of a much larger development. And there's a farm that they saved next door, has some assisted living, and then I think some future or current commercial as well. And this is a little bit closer to home, the park at Medfield. This is, again, 15 units per acre. There was a total of 92 units, 6 acres, built in 2015. And this was a redevelopment of a former commercial industrial site. And it's kind of screened from the road and near some public, I think it's near a DPW building or a brush dump as well, if you know the area. And so what happens if we don't comply? So if at any point DHCD, now known as the Executive Office of Housing Livable Communities, determines that an MBTA community is not in compliance with Section 3A, that community will not be eligible for the funds that were, stated in the law. And then also the Attorney General has further clarified and issued a statement that communities who choose not to comply will be subject to civil enforcement action. And so this is just an excerpt from the Attorney General. I do have a link to it. And Brian Winner, if you want to speak a little bit to this, I will ask you to unmute. And you can take this one slide.
Sure, I can actually, if it's okay, offer a couple comments on this. So first of all, good evening, everybody. Brian Winter from Mead, Tallerman and Costa, and we serve as your town council. So as Rachel was mentioning, there's a couple different components to what happens in the event of non-compliance. And I'm just going to sort of in broad sweeps break it down into sort of administrative remedies versus judicial remedies, and then touch upon kind of a private right of action versus a government cause of action, just to keep it in sort of general terms. So the law itself specifies that there are administrative remedies, and these are the deprivation of access to certain funds. So there are funds available through the statute. There are about 16 other state aid programs that we could be either denied access to, or we would be reduced in terms of point scoring towards, and would lose certain percentages from all or some of those grant programs. And I think we have a slide to that in a second. And so those are mechanical things that happen. They're built into the regulations. They're built into the act and the statute that implements it. And so I call those administrative remedies because the state doesn't need a judge to issue an order. Those are things that just happen if you're declared to be quote unquote non-compliant. And so I'll just say the entity formerly known as DHCD, because we don't have a great way to say the new acronym yet. we're all working on it. We just haven't gotten there. Um, uh, they are I would say, sort of conducting overtures with different towns, sending signals, corresponding, monitoring compliance. There's been a lot of interaction. We interact with the Attorney General's office as well as the state on these compliance matters. And so they are certainly keeping an eye on it. And if they determine that a community is not in compliance, the first thing they can do is rule that we're not eligible or at least demoted in terms of our status with respect to any of these state aid programs. So those are administrative remedies. And here's the chart I was referring to earlier. And this is very broad. I mean, there's a lot in here, and each one of these squares could be a 20-minute conversation about what all this means to a community. So those are things that can happen mechanically without a judge's intervention. You heard a few times a civil action mentioned. So that's a different kind of remedy. That's a judicial remedy, meaning someone can go to court and try to enforce the law. And there's two ways that can happen, potentially. One is less clear and one is very clear. The less clear version is a private right of action. So you may be aware that there are a couple communities that were resistant, I'll say. And so the state, of course, contacted them, and there was some interaction there about their level of compliance or non-compliance. And one community in particular, you may be familiar with this. I apologize if I'm telling you things you already know, but the town of Holden actually was sued. And it was in Superior Court in Worcester County, and it went in front of a judge ultimately. It began in the Supreme Judicial Court and went back to the Superior Court. And the town was successful in that case. But that was a private civil action brought by a housing group and two private plaintiffs. And the court dismissed it on account of their lack of standing. And that's a legal term of art, meaning that you don't have a case in controversy. You're not harmed in any particular way that gives you the right to enforce this statute. So the reason I mentioned that is I just wanted to be clear that we don't know if maybe a private right of action is ultimately going to exist. That case has been appealed, by the way, so it's the Superior Court's judgment. Judge Wren's decision is it's not the final word on the subject, but we don't know what direction that's going to go in. So that's why I mentioned that that's a little less clear. What's very clear is that the state has judicial remedies. So we not only know that from the regulations and the statute, but we also know that because the state, through Andrea Campbell, the Attorney General of Massachusetts, has issued notices that have been distributed saying that we will and we intend to take enforcement against communities that don't comply with the law. There are some remedies contemplated just directly in the MBTA Communities Act, but what the Attorney General has stated is something much more broad. And there was an article recently in the Boston Globe, and there's been several in different trade papers about this. But what the Attorney General has stated is that they're creating a new division within the office of the Attorney General. And they're also going to, I'll say, tap some of their other broader powers to enforce, and which would include anti-discrimination laws, federal and state fair housing laws, the Fair Housing Act. And each one of those has, the potential for a whole host of remedies that a judge might order. That could include equitable relief. It can include injunctive relief. It can include penalties and fines. So a lot could happen in those cases if the Attorney General sees fit to bring them. And all signals are that they're ready, willing, and able to do that because this is a very high level policy directive from the executive office. And so they intend to pursue this. And they've stated so clearly in Globe articles, as well as notices that have been issued directly from the Attorney General's office. So there are a lot of unanswered questions because this, of course, hasn't happened yet. But the signals have been very clear. So one thing, and then I'm going to conclude on this statement, which is right there in front of you, and I have it highlighted next to me. Non-compliant MBTA communities are subject to administrative consequences of being rendered ineligible to receive certain forms of funding. And the next sentence is the important one. MBTA communities cannot avoid their obligations under the law by simply foregoing the funding. Meaning, even if a community is willing to just give up on the state aid, they're still going to take enforcement. And we still have an obligation. All communities that are subject to the law still have an obligation. And so the state is taking this very seriously, as are the communities subject to it, which is why there's such an extensive undertaking and so much information that you've had to listen to tonight, because it's a very complicated subject matter. So thanks for bearing with me. I'll turn it back over to you. And of course, if you'd like, I'll stay unmuted in case there are any questions.
Thank you, Brian. I do have a few more slides, and then we'll get to the end, I promise, guys. So just to wrap up, some important clarifications. Section 3A and the compliance guidelines do not require that these multifamily housing units ever be built. It's just creating the zoning. Some people may say, well, heck, if I've got 25 acres and I got this overlay zoning and it's as of right, that's easier than doing a special permit. It is. And that's kind of the law, was to help those projects come forward. They still have to meet the zoning bylaw. So it's not just a, hey, here, this is what I want to do, you have to approve it. They still have to meet the bylaw that's in that we're proposing. It doesn't compel us to design or pay for new infrastructure to accommodate any of these developments. As you've seen tonight, with the board, and what you guys are very good at is going through and, getting, if there's not enough water to service a property, they're going to have to upgrade that water to get that. Sidewalks is an important thing, not only in the bylaw, but also to the state. We are also a complete streets community. All those things are going to still be taken into account. It doesn't mean that the districts have to have a uniform density either, as Angela was sort of talking about, depending on which option we go with. It's just as long as the entirety, the gross density has to be 15 units per acre. It doesn't supersede the Wetlands Protection Act or Title V. They still have to meet those regulations. If there's wetlands on the property, they still have to meet those. And it doesn't allow us to get a waiver or an exemption from the requirements either. And so again, it's just going to remove some of the zoning barriers. And as you know, we may not see development for years. It takes a while for this stuff to sort of ramp up and happen. It just sets the table for future actions. And a lot of communities are actually, they're passing these bylaws. Norfolk is one that's there, have a station right within their boundaries. And, some, of course, the press coverage, you always hear about the worst case scenario too. And the capacity analysis is, that's conducted, doesn't mean that the production of all the units will follow. As you know, some of these areas, you've all lived here for a very long time. Some of those parcels are occupied with existing buildings. Those people we're not telling those people they have to sell their property. They can hold on and continue that use for as long as they want. It's not going to come in and be torn down. It's never that, unless they want to. So what are the next steps? Well, right now we'll probably take some Q&A, but on your own, review the zoning amendment webpage. So I have a link there. Go through the draft zoning bylaw and make comments on that. Submit your comments to planning@wrentham.gov, and then those will be shared with the board for them to talk about. And we're already at this meeting, so you can't join. You have already joined this meeting. But as part of this public hearing process, the board can make changes, so long as it still meets the requirements, the compliance model, but, they may make some changes to it. Once they do that, the planning board will submit its recommendations to town meeting. Those are just a suggestion, but, the article is then placed on the warrant for the June town meeting. And then once the article passes, the bylaw is then submitted to the state attorney general for review and approval, and then DHCD or EOHLC for determination of compliance. And again, this is the resources page. So once this is up on the website, all of these are links to those pages. And you can go and check this out at your leisure. So with that, I will stop my share. And I'll stop talking.
Wow, that was a lot. But very well done. Thank you, everyone, for putting that together. I think probably we'll go down the list of planning board members first, and then we can open it up. And I'm not sure tonight is the night, because it's getting late, for all of the questions and answers. We can come back as people do their research and kind of get more acquainted with this, and come back with maybe more refined, and certainly submit them to Rachel. Then we can kind of categorize them and answer a lot of questions that might be similar. So, but for now, Mr. Cass, any thoughts, questions?
How does the 750 units